lady. Well, I can begin on Proposition 7 and putting it in perspective. The remaining two of the 5 questions that I posed at the start of Proposition 6 are relevant to the point we make here about special category. Those 2 questions in relation to Proposition 6 were, did the rationale for Bland disappear with advances in medical science, and are such cases deserving of special protection? They merge into each other because the state of medical science is one of the factors that affects special category. Now, in advancing the proposition that these kinds of cases fall into a special category, we do not, of course, seek to suggest that CANH as a form of medical treatment is unique to PDOC cases. Nor do I seek to suggest that there's absolutely no other case that could not plausibly be the subject of a requirement for a court application prior to the withdrawal of CANH. This court is not concerned with the detail of other cases, and for the reasons to which I'll come, we refute the proposition that our case demands equal protection for all cases in which CANH is proposed to be withdrawn, or that the points we make relate logically and inexorably to all the ICU, the intensive care cases, or that the points we make relate inexorably to the so-called third category of case referred to in the BMA's case. What we say is, first, that PDOC cases have, for the last 20 years or so or more, been treated as being in a special category, both as a matter of case law and of parliamentary endorsement. Medical practice has recognized and applied that distinction without obvious difficulty. If it was appropriate to treat such cases as being in a special category from Bland onwards, nothing has changed in medical practice to justify altering those protections now. That's the first point we make. Secondly, we say that the special treatment accorded to PDOC cases was and remains entirely justified. Such cases have the following special features which, in combination, make them obvious candidates for the common law and convention protections for which we advocate. The key special features which we seek to identify are these. First of all, the real dangers of misdiagnosis in such cases. Secondly, the challenging nature, the very challenging nature of a best interest evaluation in such cases, with the nature of the evaluation being one that ought, given the potential for minimal consciousness states, to be subject to the ultimate determination of a court if requested to do so by a neutral third party. In such cases, there is clinical stability, rather than, to use the BMA's own words or phrase, downward trajectory, which complicates the task of evaluating best interests. And thirdly, the question that your ladyship asked me before lunch, to many, the morality of CANH withdrawal in this kind of case causes visceral concern. Morality and perception is, we respectfully submit, a relevant factor to take account of when it comes to identifying and applying the law in this difficult and sensitive area. And the third point we make is that none of the reasons identified in the case law subsequent to Bland, and I'm really referring to the recent cases, confront these special features of CANH withdrawal in PDOC cases. So may I start with those 3 points. So the first point, recognition of CANH PDOC as a special class of case. And we say that if there was a compelling rationale, as there plainly was, earlier submission I've made, for the implicit recognition in Bland that PVS cases fell into a special category, deserving of special protection. After all, the position in relation to medical treatment in Bland 20 years ago comprised many cases, of which PVS cases were but one. So if there was a compelling rationale for the implicit proposition in Bland that these cases fell into a special category deserving of special protection, nothing, we say, has changed to alter the need for such protection to be continued. It should be borne in mind that at the time that Bland was decided, nothing was known about the distinction between PVS and MCS cases. That simply was not known to the House of Lords. The recognition that PVS cases required protection is our fortiori when it comes to MCS. I'll come separately in a moment to the problem of diagnosis and the particularly difficult nature of the best interest evaluations that have to be made in consequence of that distinction. But the point I want to make at this stage is that the established body of practice that the House of Lords envisaged, or perhaps hoped for in Bland, has not been built up in any way that would now render applications to the court in PDOC cases as unnecessary. The opposite is the case. So while in the years since Bland there's been greater refinement of the criteria and the terminology to be applied to PDOC, experience suggests that there is now more, not less, uncertainty as to diagnosis. The body of experience that the House of Lords thought might in future obviate the need for an application has simply not materialized. So whilst clinical research has refined the glossary and the tools of diagnosis, the structured assessments and so forth, and important publications such as the Royal College of Physicians 2013 guidelines have distinguished and set criteria for PVS and MCS, differentiating the subtlety of diagnosis is now a more demanding clinical task, as those guidelines, to which I will come shortly, exemplify. It is, we suggest, of note that the respondent's case does not, as we read it, seek to suggest that the body of experience envisaged in Bland has been built up. And I think I'm right in saying that, again, the wisdom of Mr. Justice Baker in the article I've already cited, Authorities 6, tab 57, page 434, at memory stick 2339, he said, when the House of Lords in Bland predicted that the time would come when applications would no longer be required as a matter of routine, their lordships anticipated that a body of experience and practice would be built up. But, as I hope, demonstrated above, both medical science and the law are still evolving. It is, of course, not only Bland that recognised that CANH PDOC cases should be scrutinised by a court before withdrawal of CANH. That recognition was separately accorded by the Mental Capacity Act Code of Practice, which was issued by the Lord Chancellor on the 23rd of April 2007, pursuant to Section 42, subsection 1 of the MCA. Section 42.4e of the MCA, which is at memory stick pages 306 to 307, provides that a person acting in a professional capacity must have regard to the relevant code. And we set out in our case, for convenience, at paragraph 49, the paragraphs of the code which are highly relevant. First of all, paragraph 5.36, as mentioned in paragraph 5.33 above, where there is any doubt about the patient's best interests, so it's the same formulation, of course, an application should be made to the Court of Protection for a decision as to whether withholding or withdrawing life-sustaining treatment is in the patient's best interests. 6.18, some treatment decisions are so serious that the court has to make them unless the person has previously made a lasting power of attorney, appointing an attorney to make such healthcare decisions for them, see Chapter 7. Or they have made a valid advance decision to refuse the proposed treatment, see Chapter 9. The Court of Protection must be asked to make decisions relating to the proposed withholding or withdrawal of artificial nutrition and hydration, ANH, from a patient in a permanent vegetative state, PVS. 8.18, prior to the Act coming into force, the courts decided that some decisions relating to the provision of medical treatment were so serious, this echoes ACCG, in fact, that in each case an application should be made to the court for a declaration that the proposed action was lawful before that action was taken. Cases involving any of the following decisions should therefore be brought before a court. Decisions about the proposed withholding or withdrawal of artificial nutrition and hydration, ANH, from patients in a permanent vegetative state, PVS. 8.19, the case law requirement to seek a declaration in cases involving the withholding or withdrawing of artificial nutrition and hydration to people in a permanent vegetative state is unaffected by the Act. And as a matter of practice, these cases should be put to the Court of Protection for approval. The last paragraph, by the way, 8.19, would seem to be fatal to the respondent's case on the common law being superseded by the Act. But that aside, The point we make here is that the statutory code itself accorded independent recognition of the seriousness of decisions to withdraw CANH from PDOC patients. And as I've said, it's consistent not only with Bland, but also with the underlying reasoning of your ladyship in ACCG. We also say that the most relevant provisions of the code that I've read out have been neglected in the analysis in recent case law. They cite the code, Lady Justice King, in one of the cases without citing these important passages. But I'll come to that separately. May I say, incidentally, this is perhaps the point at which to say it, when your ladyship raised just before lunch the question of Law Commission, I take it your ladyship has read our paragraphs 39 to 41 in that context, which refers to the Law Commission's report. I appreciate it doesn't necessarily answer your ladyship's question.
Well, my question was a different one.
It was. All I was going to say was, and I'm not going to say more than this at this stage, because we obviously need to reflect on it, that the assurance given by David Lammy, MP, and I gather there's another citation from Rosie Winterton to similar effect, might give rise to a certain inference, that inference being that if there's going to be provision in a code retaining the law, it may not be necessary to enshrine in an act the recommendations of the Law Commission. But that certainly is there's nothing I can say to give concrete validity to that. It's just an inference that might perhaps be drawn.
Tomorrow, could we have copies of the relevant chapter or part of this Commission report?
You can, my Lord, yes, if it's not in we will get that.
Thank you.
So that's point number one, the recognition of the special status of CANH PDOC cases. Point number 2 of 3 in this 7th proposition is the unique nature of PDOC cases, that recognition aside. And so first of all, the problems of misdiagnosis. Now, as the Royal College of Physicians guidelines makes clear, and can I just refer to the memory stick, page 2433, and the materials there cited at footnotes 27, 29, and 30, at memory stick page 2528. And I'll just quote from the guidelines: misdiagnosis remains a significant problem in PDOC as a result of either diagnostic error or change in the patient's condition over time. And a rate, as we understand it, of PVS of over 40%, a rate of misdiagnosis of PVS of over 40%, has been consistently found in research. That material, though it's not in the bundles, but it's cited at footnote 49. And at page 2435 of the memory stick, the same guidelines, quote, that misdiagnosis most commonly arises from a failure to recognize that the patient is deaf-blind, aphasic, or that responses are masked by paralysis, physical status, or position. It's also to be borne in mind that Bland was decided before smart testing and the advent of WHIM. Their lordships may not have anticipated the diagnostic complexity of establishing PVS and MCS. As I say, MCS wasn't even known about then. Diagnostic mistakes are still made, even by leading experts in the field. Now, do we have this case? Is this in the bundle? Yes. Now we have, I'm afraid, if the court can bear it, another bundle which might be useful to hand up at this stage, because my learned friend has material he wants to put in and is in this bundle, and this relates to a specific case on misdiagnosis.
Do you have to put them in enormous lever arch files like that? I mean, do try and have some consideration for those of us who have to carry these things around.
Yes, my lady, I apologise. I'm afraid a lot of this has been caused by pressure of time, but if we may hand this up, at least I can make a point about this, some of the case law where there has been misdiagnosis.
Lady, I've got a smaller one that I could swap with one of you. May help.
Well, that's very sweet of you, but I think I can do it myself. Part of the worry is that you're going to fill this with further material.
Well, I sincerely hope not. I don't want to labour this, but the first 4 tabs, I think I'm right in saying, are all relevant to this case. And so what we have is the actual order in the case at tab 1. And we can see there that from the terms of the order, that a smart assessment report in respect of the first respondent has concluded that the findings from SMART 2016 and the team indicate a diagnosis of MCS and emergency.
So what name shall we ascribe to this case?
It's an unreported case. It's number 128363994.
Do you not think we could give it a name, obviously anonymise it?
Nottingham.
Yes, any name, my lady, we'd be content with that. Did I hear my Lord Mance say Nottingham? That's a possible name for it.
Might call it X.
We'll do that in a minute. Can I let the court just read that order rather than read it? Is this the original report from Wade? So we can see what happened there. The application was withdrawn. The report, or one of three reports actually, from Professor Wade is at tab 2. And perhaps I can just, at this stage, without labouring this and going into detail, invite you to look at paragraph 7.3 for the view then taken. We can see Mr. Badwan's report at tab 3. And we can see at 8.2 of that tab the prognosis that Mr. Badwan gave. Perhaps 8.2.2, just to make the general point, the trajectory of recovery has been such that although it appears to be slow, there's consistent improvement in IB's condition. And the point really to be made is not to be critical. I know that Professor Wade has yet more material that I think my learned friend would like to hand to the court. But I just want to make it clear, we are not being critical of the diagnosis here. I think that it is accepted that there was a misdiagnosis, but that's not the point. The point is that when you get another expert, there can sometimes be the potential for a doubt, which wasn't there if you just took the initial reports. Another case is afforded, and this is talking about leading experts, let alone much lower down the field. Another example, I think, is afforded by the decision of Mr. Justice Baker in Re M, memory stick, page 1467. And I just wanted really, can you give me the case there?
Can you give us the
I
bundle,
think I'm right in saying
the
that.
bundle number and the
Just
tab
want to check
number?
that, yes. I think it's bundle 4, tab 32.
Thank you.
I just want to be sure about that, so. Is that right? Yes. So if I can take you to paragraph 15 of that case. We can see that Dr. W, the consultant in rehabilitation medicine at the hospital responsible for treating her, can I have that? Expressed the view that M had suffered irretrievable and severe brain damage, that she was unlikely to improve, and that she'd reached the stage where she should be cared for in the community with appropriate nursing support and help. And then at paragraph 16, page 1468, 1660 G to H, Professor Andrews, for the family and the trust, reach a conclusion of PVS. Paragraphs 18 to 19, similarly 1468, page 1660, Mr. Badwan, for the official solicitor, concludes that there was no structured assessment and that there should be a structured assessment to assess P's level of awareness. Paragraph 21, page 1469, memory stick 1469, 1661 of the report. The SMART assessment gives a different picture. Paragraph 22, page 1470, 1662 of the internal numbering, patient transferred for rehabilitation. And then there are differing views expressed respectively at paragraphs 24 to 24 and 30, 24 for 1470, page 1662, and then a joint report is put in, and you'll see that at paragraph 30. But this is simply to illustrate, not to as I say, to criticize, but to illustrate the real potential here for misdiagnosis, and that's at the highest level. And one might say that those with less specialist expertise could be expected to make more errors. An example of that appears to be the case of St George's Healthcare NHS Trust against P&Q. See Authorities Bundle 5, tab 43, at memory stick page 1951, where, I hope my summary is not in any way distorting the facts of the case, but I do it for reasons of economy. The clinicians' entrenched view was that their diagnosis of PVS was correct, such that they believed that smart testing would be an expensive waste of resources. It led them even to revisit the family's request to film P, but when there was video evidence in front of a court, it proved crucial in establishing to the satisfaction of the court that P was in MCS and that on considering best interests from P's unique perspective, withdrawal of CANH was not in his best interests. And it's no doubt cases like this that have led, in particular, Mr. Justice Baker to the views that he expresses in his lecture. So it's therefore unsurprising, we say, that there is a real danger of diagnosis. I want to give you a few references, given the time constraints in the bundles, rather than taking you to the materials, which show the real problems of, real dangers of diagnosis and misdiagnosis. First of all, Mr. Badwan's report in this case, where he did suggest that further investigation might have been helpful, although it's fair to say he didn't examine Mr. Y. So we find that in the core bundle, memory stick page 266, and I would refer particularly to paragraphs 3.2.7 and 3.2.8. We have a post-note, parliamentary post-note, Authorities, Volume 8, tab 77. I think it's memory stick page 3144 in the left-hand column, second paragraph, under the heading Diagnosis and Prognosis Clinical Assessment, quote, given these factors, misdiagnosis is common, with up to 43% of patients initially thought to be in VS, subsequently found to be in MCS. We have Professor Sturman's report of the new bundle, tab 11, paragraph 2.10, and we have at tab 25 of the new bundle, a report by C. Schnakers and others, and we have Professor Wade's responsive article, tab 4 of the new bundle, saying it's not as bad as it's presented in some instances. But the real point here is not to labour it or to go into the medical detail in any great detail, but to make the point that this is an extremely difficult area for diagnosis, and mistakes are definitely made. Can I move to the second point on the special status of these kinds of cases? The challenging...
Sorry, you're referring to...
I was looking at the new bundle. That's
Yes.
to say, not the... Yes, it's this one, isn't it? It's a supplemental documents volume.
Not the new bundle.
Not the new bundle. I mean, it was a new bundle when I wrote this. But it's the supplemental bundle at tab 11 for Professor Sturman's report, tab 25 for the Schnakers article.
Sorry, tab 11 of this.
No, it's not the new one.
No, it's not the new one.
I'm sorry, when I said new, my lord, I meant supplemental. I'm sorry about that.
Well, tab 4 was the new one, wasn't it?
But tab 4 is the new bundle, I think
Yes.
that's right. Yeah.
Let's go back. Give us the references in this bundle, now you've identified it.
In this new bundle, or the whole lot?
In the bundle that you want us to look at.
Yes. Well, I've given you Mr. Badwan's report, reference 4. I hope I've given you the reference for Mr. Badwan's report.
Professor Sturman's report is tab 11
Supplemental.
of the supplemental.
That's correct.
Bundle. Yeah.
Schneeker's is that the Schneeker's report, worth looking at, but I'm not going to go to it now, is tab 25
In the supplementary
in
document.
the supplemental bundle, and then this one is tab 4 of the new bundle. Supplemental, all right. And Professor Wade's article is tab 4 of the supplemental bundle.
Nakers.
So these are scattered references
That's
to,
tab 4 of the new bundle.
of the supplemental bundle.
Oh.
I mean, I'm in great danger here because when
Wade is tab 4.
when I prepared this was
Oh, I see, yes.
the new bundle, and it's my fault for causing the confusion.
It's just a confusion that Wade is tab 4 in both bundles.
Yes, that is also true and also confusing. I will point to just one more source on this, if I may, before leaving the materials that suggest misdiagnosis, and that is the Royal College of Physicians Guidelines, memory stick pages 2482 to 2483. And if I can invite you to read those 2 pages, they will...
Again,
248...
helpful to have the bundle on the tab.
Yes, of course. Memory stick pages 2482 to 2483, and I'll give you the tab in one moment.
Thank you very much indeed.
662, tab 62.
Thank you.
But those 2 pages, 2482 to 2483, give quite a graphic picture of the exceptionally challenging nature of misdiagnosis in this form of case. And best interests. So when we look at minimally conscious state at 2482, we can see that MCS covers, I'm reading from 2/3 of the way down that page, a wide range of variation in responsiveness and awareness. For some patients, it's a transitional state on the way towards fuller or full recovery of consciousness. Others will, however, remain permanently in a state of diminished consciousness, and it's this group for whom there's special ethical concern. Further material there, and the point made at the bottom, life-prolonging care may therefore have negative values for patients who experience some minimal awareness but have little to no hope of further recovery. For these reasons, the bottom of 2482 going over to 2483, the best interest decision-making in respect of someone in MCS is particularly complex and often finely balanced. The law at this time of this report offers little guidance, as there's only been one court case concerning the withdrawal of CANH. So the point I wanted to make here is, not only is there the potential for serious errors of misdiagnosis, but when we look to the separate point about best interests, we are dealing here with a particularly challenging task in which sometimes you'll be looking at clinical factors, but you'll obviously also be looking at a whole range of other factors. And we do, with respect, say that this is a task particularly suited to a court, certainly as the ultimate arbiter. And the fact that a court and a clinician can have different adjudicative or evaluative functions is exemplified in the case we cite, Montgomery and Lancashire Health Board, which is Authorities Bundle 4, tab 33, in which it was held at paragraph 83, memory stick, page 1540, that, quote, responsibility for determining the nature and extent of a person's rights rests with the courts, not with the medical profession. Now, without wishing in any way to diminish the importance, this comes back to what my Lady Hale said earlier, the importance of a best interest evaluation in any end-of-life case we respectfully disagree with the ICU FICM argument that there is no reason to distinguish CANH from the removal of other forms of life-sustaining treatment, and that either all cases involving withdrawal of any form of life-sustaining treatment must be brought before the court, or they should be left to statute. With respect, that argument ignores something quite fundamental. A patient in PDOC who's receiving CANH can survive outside a hospital setting with nursing care alone. By contrast, the patients, the focus of the ICU FICM submissions, are in receipt of the most intense form of care or organ support, without which they would die very shortly, if not immediately. A clinician caring for a patient who in all likelihood will be dependent on such support indefinitely, as opposed to during the immediate aftermath of an accident or for a finite period post-operatively, is facing a scenario in which the death of his patient is sadly, without invasive treatment, imminent. That is, we say, wholly different from a doctor caring from a patient in PDOC who relies on CANH and may have a life expectancy of a decade or more, reliant on nursing care only. We suggest, therefore, that there is a distinct difference between decisions that are taken on a daily basis by intensive care practitioners, involving, indeed, withholding and withdrawing life-sustaining medical treatment in line with the principles of the MCA, which may or may not involve CANH, and any decision-making with regards to withdrawal of nutrition and hydration from a physiologically stable patient with an otherwise indefinite life expectancy in a non-acute setting. For its part, the BMA submits that there is a separate third category of patients who, like PVS-MCS patients, could, with CANH, potentially live for a number of years. This is said to include patients who have suffered a severe stroke, those who are significantly cognitively impaired but conscious, or those patients with degenerative neurological conditions or other conditions where there's a recognized downward trajectory. That submission is descriptively correct in that a different cohort of patients to that where responsibility lies with intensive care practitioners does exist, such patients falling within the care of stroke physicians, neurologists, gerontologists, and so forth. But as set out within its submission, these decisions arise in the context of a recognized downward trajectory, as opposed to a physiologically stabilized patient. The very creation of a so-called third category itself reflects a distinction, but not, we say, a distinction that detracts from the special position of PDOC cases and the very careful balance in terms of best interests that have to be made in such cases. And then finally, on this part of the argument, the moral dimension. And it is apparent that the withdrawal of CANH in PDOC cases raises distinct moral concerns. That was observed as relevant to the way in which the law should be applied. And the RCP guidelines itself refer to this. So can I invite you to look at them again at page 2479 to 2480, memory stick. Again, can I have those guidelines? This is authority 62. It's authority volume 6, and it's pages 2479 to 2480. I thought it was. And it's one can see it really on 2480. There remains ethical debate about withholding. Well, perhaps it starts a little earlier. At bottom of 2479, whilst life-sustaining treatment may encompass a number of interventions, including resuscitation in the event of cardiorespiratory arrest and the use of antibiotics in the case of a life-threatening infection, the most emotive is artificial nutrition hydration, ANH. This is partly because nutrition and fluid are considered by some to be staple requirements rather than a medical treatment, and partly because death will inevitably follow within a few days or weeks of withdrawal. Recent General Medical Council guidance has introduced a change in terminology from ANH to CANH, etc. There remains ethical debate about withholding and withdrawing CANH for people with PDOC, and we see that it's rooted in what is causing the patient's death, the value of life for patients who are conscious but unable to experience beyond a basic level, and are not terminally ill in the conventional sense, and whether death by dehydration may cause suffering, especially in patients with MCS. From a legal and ethical perspective, the catastrophe that led to the brain injury is the ultimate cause of the PDOC and subsequent death, and the guidelines then set out why that is so. But then the last paragraph here, the difficulty is that the longer a treatment is in place, the more it feels normal. Hence, withdrawal of CANH may seem like a new or separate cause of death, and clinicians may feel as though they are actively terminating life, rather than simply desisting from intervention to postpone death happening. However, staff should be reassured that they are not legally culpable as long as the proper legal decision-making process has been followed. But as I say, this is not so much a question of culpability as a question of how does this slot into the special category for which we are submitting. So that's our point 2 of 3. The last point on this is the case law since Bland. And we address the recent case law in our case between paragraphs 51 to 59. I don't propose to go through those cases in detail, but I should make a few points about the cases referred to between paragraphs 54 and 58, mainly to pick up on submissions already made, and also because some of these cases are the ones that are beginning to change the tectonic plates, certainly in the recent few months, or perhaps a year or two. So we can start with a fairly safe source, Mr. Justice Baker, in Re-M, Authorities, Bundle 4, tab 31, and I just invite you to look at paragraph, I think it's 257 at MS page 1505, Mr. Justice Baker there reiterating that all applications concerning the decision to withhold or withdraw CANH from a person in a vegetative state or minimally conscious state must be referred to the court pursuant to the then existing practice direction, which of course existed at the time of this case as well.
What was the page reference that you gave?
Page reference in memory stick is 1505.
No, 1458, I think.
Is it? I'm sorry if that's a false reference. Can we have a look at 257?
1505 is correct.
Yeah,
458 is correct.
maybe it depends which.
257, you say?
57.
I thought it was 257, yes.
Decision to withhold, yes. Must be referred to the...
It says 257 and it's 1505, but yes, I see what's happened.
What's happened?
I think the cases at 31 and 32 are the same case, actually, but can I just read it anyway? First, it's important to reiterate that a decision to withhold or withdraw ANH from a person in a vegetative state or minimally conscious state must be referred to the court. All applications of this sort must be made to a High Court judge, furthermore good practice dictates.
But of course what he's doing is referring to the Court of Protection Practice Direction, which has since been
I agree.
withdrawn.
Although the reason why it's been withdrawn appears to be that, or at least maybe, because the MCA didn't change the law and you didn't need you shouldn't have a practice direction which tells you when you can or can't go to court. But the code, of course, still subsists. So that's Re-M. And I pray and aid not just the fact that you've got a decision of Mr. Justice Baker, but you have to also look at his views in the Shrevell lecture that I mentioned earlier. And
That too was based on it referred to Practice Direction 9E
yes,
as authority for the...
I have no problem with accepting that at the time of this case and at the time of in Re-M, there was a practice direction. But as I say, we still have the statutory code, and you have all the submissions I've made, but I'm simply going through the cases. That's the first of the cases. But that was revisited in the case of Briggs by the Court of Appeal, and you find that case in Authority Bundle 2, tab 12. She made the obiter comments recorded in our case at paragraph 55, and you can find her comments in the case itself at... She.
Lady Justice.
I said Lady Justice. Oh, did I not? Well, I know it's Lady Justice King.
You know it's Lady Justice King.
And I meant to say Lady
Not everybody in the room knows it's Lady Justice King.
I did mean to say she anyway.
Yes.
Yes, by Lady Justice King, she made the obiter comments recorded in our case at paragraph 55, see paragraph 108, and echoed by Sir Brian Leveson, and you find the references in the memory stick at pages respectively 852 and 854. And perhaps I should read what Her Ladyship said. The proper approach to a case where the central issue is medical treatment, serious or otherwise, following Ferreira, is therefore as follows. 1, if the medical treatment proposed is not in dispute, then regardless of whether it involves the withdrawal of treatment from a person who's minimally conscious or in a persistent vegetative state, it is a decision as to what treatment is in P's best interest and can be taken by the treating doctors who then have immunity pursuant to Section 5 MCA. 2, if there is a dispute in relation to medical treatment of an incapacitated person, and specifically where there's a doubt as to whether CANH should be withdrawn, then the matter should be referred to the court, etc. Now, as far as we can see, paragraphs 6.18 and 8.18 of the Code, which I mentioned earlier, were not put before Lady Justice King in argument. When Her Ladyship referred to the Code, see memory stick page 834, paragraph 20, she referred only to paragraph 5.36, the terms of which are less prescriptive than those of 6.18 and 8.18, and indeed 8.19. That meant that Her Ladyship's obiter comments at paragraph 108 were made without argument on the point, and certainly made without an analysis of the point. Her Ladyship's ruling was, of course, material to the reasoning of Mrs. Justice O'Farrell. See judgment again in paragraph 41, memory stick page 156. So we say that those were important paragraphs of the Code, and they simply were not looked at. In the subsequent decision of M, Authorities Bundle 2, tab 14, Mr. Justice Peter Jackson, as he then was, held, see paragraph 37, memory stick, I think, at pages 950 to 952, held that there was no statutory obligation to bring an application to withdraw CANH from someone in a minimally conscious state, nor was there an obligation to do so pursuant to Article 2. And the learned judge gave 4 reasons for the conclusions that he drew. See paragraph 37.2, little Roman 1 to little Roman 4, as I say, memory stick pages 950 to 952. And we gut or summarize those reasons in our case at paragraph 57. So the reasons are, first of all, overwhelmingly treatment decisions up to and including the withholding and withdrawal of life support are taken by clinicians and families working together in accordance with recognized good practice. No one suggests that these decisions should be the subject of external supervision. 2, are these cases so different in kind to other serious medical treatment decisions as to justify a completely different approach? In my view, they're not. The reasons for requiring all PVS MCS cases to come before the court could equally apply to a very much larger patient population. Pausing there, those first 2 points are points in relation to which I've already made submissions on the distinct category of PDOC cases raised by the withdrawal of CANH. And it's not at all clear that there was evidence of that aspect, or it was considered, even if it was, the learned judge hasn't really, in our respectful submission, correctly ruled on the differences that do exist, the material differences. Third reason, a mandatory litigation requirement may deflect clinicians and families from making true best interest decisions, and in some cases lead to inappropriate treatment continuing by default. Well, we say that that ignores the reasons, again, for differentiating PDOC from other cases that I've already advanced, because there's a whole range of misdiagnosis and best interest evaluations that are certainly not trumped by this reason. And then finally, it is not suggested that the court should be involved in PVS MCS cases where there is a valid and applicable advance decision, yet the grave consequences of the decision and the risk of error are no different in such cases. Well, we say there that the learned judge fell into error by equating advance decisions in PDOC cases with the kind of case with which your ladyship and your lordships are concerned on this appeal. Where there's an advance decision, P has made the decision as to when and in what circumstances his life should end. In stark contrast, where he has not made an advanced decision, he's left voiceless unless the court or third party is able to assess what is in his best interest and raise identifiable doubt.
But it depends, of course, on the terms of the advance decision. But if the advance decision was limited to PVS situations, all the problems of diagnosis you've identified would again exist.
Well, there may be some PVS cases where you may need to approach the court, but the point I'm really making is that you can't necessarily equate an advance decision context with the kind of context we're concerned with here. And the evaluation of whether an advance decision has been made is of a completely different order, really, to the best interest evaluations that have to be made in these kinds of cases. All we say is it's not a reason for saying that these cases don't deserve special protection by comparing it to that which you're really comparing apples and oranges. So, at something of a canter, those are the 7 propositions. We accept, it's obvious, I would be silly not to accept it, that the law may be approaching a critical juncture here. But the stage has not yet been reached in our respectful submission in the development of either hard data or medical science or law where the need for an application can safely be dispensed with. In the supplementary bundle at page 87, we have, do you have a tab number for that? I'll give you the tab number in a moment, if I may. Freedom of information request. Professor Turner Stokes saying, neither the Department of Health or NHS Digital can collect any data that would identify patients in PDOC. Therefore, there are currently no good data on how many PDOC patients there are in England. I'm told that is tab 5, Supplemental Documents, Volume 1. And page 87 of the... Sorry? It can't be tab 5. Oh, well, where is the bit that I've quoted then? Neither the Department of Health. Sorry, I may have given you an incorrect reference.
Yes, I think so.
Yes, it is.
Are there any bad data?
Bad data.
Yes, I mean, it would be obviously helpful to get some impression of the numbers of people involved, even if they're not good data from a scientific point of view, and compare those numbers with the number of cases that are actually brought to court.
Yes, it's 57, by the way, the page. Sorry for that. There's a post note at core volume. Sorry. Oh, that's a reference to this, you mean? Sorry, all right. I don't know the answer to your Ladyship's question, but again, I may have to come back to that if I may. The point really here is that it may be that in the future, the certainty around the assessment of patients in PDOC will become far greater, and consensus between clinicians more likely, or that sufficiently robust mechanisms can be devised to ensure patient protection. Until then, we suggest respectfully that the need for external scrutiny through the present mechanisms, that's to say through the specialised judiciary, within the Court of Protection is vital if the United Kingdom is to meet its convention obligations and common law protections. Practical problems caused by delay can be managed in a proportionate manner through more effective case management. One can well imagine that there may be improvements to the system that can and should be made. One can even imagine a system in which, in the future, a third party such as the official solicitor would have the opportunity to undertake investigations and funding would be made available for that without the need for court proceedings. But as I said at the very beginning of the case, of this appeal, I'm not in a position to make submissions, to make useful submissions about what that system should be. The real questions that this court has to resolve is really addressing, because I can't think of any better way of analysing it, each of the 7 propositions that I've advanced. As I say, the first 3 are largely concerned with the declarations granted in this case. That's the narrow point. But the central point, you have to address really what's been the effect of the MCA, what are the content of the Convention and common law rights, and is PDOC CANH a special class of case? We're either right or wrong about that, but in our submission, that is the correct and only way properly to analyse the issues that arise on this difficult appeal. I'll just check that. Yes, Your Ladyship asked a question about bad data, or at least other data. My attention's been drawn to volume 8 of the authorities bundle, tab 77. There is a post note. It's memory stick page 3143.
Is this the same post note that you referred us to earlier?
I think it is, but this gives you some more figures. It's the right-hand column, last paragraph. Because PDOC can result from numerous initial diagnoses, there are no reliable statistics on incidence or prevalence. Estimates based on number of patients with PDOC in nursing homes in the UK range from 4 to 16,000 patients in VS with 3 times as many in MCS. So that may or may not be good data, but it's other data. What's this doing? And I understand that Professor Wade has given a suggested rationale for those figures, the number of 16,000, and we find that in Supplemental Documents, Volume 1, Tab 12, Supplementary Memory Stick, pages 225 to 226. And right at the foot of page 225, Professor Wade says this: I estimated about 2 to 3 people aged 16 to 70 in the vegetative state from an acute onset brain damage per 100,000 population in Oxfordshire. It's almost certainly an underestimate. Published studies suggest up to 3 to 100,000. Given that there are many older people left in this state after stroke and many younger people in this state from multiple sclerosis and many other disorders, I guessed a prevalence of 10 to 25 to 100,000. The estimate of 3 times is largely based on first principles. In any spectrum, the proportion of the extreme is always much less than the proportion who are less severe. I personally probably know of 50 to 100 people in a prolonged disorder of consciousness. I know of nursing homes where there may be 10 to 20. There are very large numbers of nursing homes. I'm not sure why you need to know, but the numbers are likely to be much higher than anyone realizes. And that's Professor Wade. So perhaps also...
Well, his last comment, which I think is the interesting one.
Sorry that I missed that.
The official solicitor's office only sees a small, probably very small proportion of cases.
Yes. Yeah. My lady, there's also, I had noted that there was a replacement authority at tab 78, and you have a separate bundle for that, I think. And that deals with the cost analysis. So whilst we're on figures, cost is at least worth looking at. This study was, as we can see in the acknowledgements, inputted, if that's the right word, by Professor Turner Stokes, Celia Kitzinger, Derek Wade, Victoria Butler-Cole, Vikram Sachdeva, and other members of the CDOC group. And this is setting out a series of costings, but I wanted really to draw your very brief attention to MS page 3159. This is on the context of guidelines. I mentioned that in my analysis of Lambert. So just before you get to paragraph 1.5, the last paragraph there, in practice, however, the relevant guidelines are not always followed, and all the appropriate medical assessment processes and meetings between family carers and clinicians are not always undertaken prior to the initiation of declaratory relief proceedings. It's not clear, however, that accounting for these empirical realities would substantially change the results. And over the page, page 3160, last paragraph, finally, our analysis does not focus on decision-making about patients in a minimally conscious state who have intermittent and various levels of awareness. And of course, one of the points we make is that it's the overlap between PVS and MCS, which is quite important. And then finally, over the page 3161, under ethical considerations, a cost analysis must be sensitive to the view there may be areas of medical practice where economic analysis should not be undertaken. It may seem unethical to consider financial costs, however, and 3 reasons there set out for why it is appropriate. The analysis focuses on cases where the family and treating clinicians all agree. Analysis does not aim to inform patient-level decision. And that is that. So we say that, we say resources can't really sensibly apply if one is concerned with this type of case, but the study that's been presented doesn't actually purport to deal with MCS cases at all. Oh, yes. And the last point I'm asked to make, in the supplemental documents bundle, volume 1, tab 10, you have a witness statement from those instructing me as to how quickly a case can sometimes be managed. And what we see from that, really cutting to the chase, at paragraph 26 at page supplementary memory stick, page 203, paragraph 26, in total, just short of 8 weeks passed from the date upon which the application was issued, 21st of December 2017, to the date upon which the final order was made, 13th of February 2018. So this is a case where, which perhaps shows, I think it was Mr. Justice MacDonald, the case was managed very effectively and very quickly. So it can be done. Unless I can assist the court.
Can I just ask you a very practical question, please?
Yes, of course, madam.
Is the patient a necessary party in the, according to the rules, in a declaration case such as this?
I think, no, I think the litigation friend is not a necessary party.
No. And so how, is it convention that they're joined?
I think so, yes.
And where does the funding come from?
Well, my understanding is that, how is it? Legal Aid Section 21, is it? Yes. Yes, that's it. So, yes, the way in which, as I understand it, my lady, the official solicitor's office is funded is either through legal aid or, if he's approached before proceedings occur, I think the convention is that half his fees are paid and he undertakes investigatory work.
Half his fees are paid by?
By the trust, yes. That's how it happens. I think I've just managed, judging by the clock. I hope so.
Judging by this clock?
No, judging by my watch compared to what your ladyship told me about this clock.
No, but judging by this clock,
Thank you very much.
you're a minute early.
Well, it always helps to be in time.
Yes.
Thank you.
Thank you very much, Mr. Gordon. Well, Ms. Patterson, have you anything to add? Yes, Mr. David.
My ladies and my lords, just on that last point, as I understand it, the official solicitor uses his own funds to fund these cases, 50% of which are reimbursed by the applicant trust. Family is not entitled to non-means tested legal aid, which is a problem identified first by Mr. Justice Baker in W&M, repeated, I think, in Briggs and Briggs, which held that you couldn't bring a serious medical treatment case via the mechanism section 21A of the Mental Capacity Act, the deprivation of liberty provision, which does attract non-means tested legal aid. But the funding position is the applicant trust pays for its own expenses in these cases, and by convention pays half of the official solicitor's own costs, and the family is not funded.
Is the person concerned, the patient, or P anyway, if a party and it's only if the person is a party that the official solicitor is going to be involved,
Indeed.
is the person entitled to non-means tested legal aid?
They're not.
No, I thought not.
They're not.
No. They're entitled to legal aid, but not non-means tested legal aid.
Indeed.
And of course, it's entirely possible that the person may have resources.
Well, they may, or the resources might. Things may turn out not the way one expects. In M, the 2011 case, because of a forced sale of property, the patient became disentitled to legal aid, and families' representatives had to carry on for free. So funding is an issue in this area. There is a lack of funding for families. This is an appeal against paragraph 1 of the order of Mrs. Justice O'Farrell, dated 13 November, appendix page 2, MS page number 143, to the effect that it is declared that it is not mandatory to bring before the court the withdrawal of CANH from Mr. Y, who has a prolonged disorder of consciousness, in circumstances where the clinical team and his family are agreed that it is not in his best interest that he continues to receive that treatment. The issue specific to the facts of this case is, was it lawful for the judge to make the declaration that she did and hold that it was not mandatory to issue best interest proceedings relating to CANH in the Court of Protection? And that is agreed in the Statement of Facts and Issues, paragraph 1A, page 1, MS, page number 47. And we say the judge was correct to make that order on the facts. And there were facts. There was a report from the treating clinician, 2 reports from the treating clinician, evidence from the family, which I will take the court to very briefly, and evidence from an independent third-party consultant. And there was substantial agreement on the medical evidence that the prognosis was a very limited one, and given what the family said about what Mr. Y would have wanted, he was not a man who made distinctions in his mind between a vegetative state, a persistent vegetative state, or a minimally conscious state. His family said he would have wanted a good chance of returning to his previous active lifestyle. And that was the best interest decision that would have been relevant had it gone to the Court of Protection. In those circumstances, we say that the judge was right to make the declaration that she did. But in making that declaration, she necessarily determined a point which is of general importance before this court, which is determining whether the blanket rule that has existed since Bland, requiring all cases of proposed CANH withdrawal in PDOC to come to court, regardless of whether there was any dispute or difference in anything in the case, medical diagnosis, medical prognosis, or best interests. Now, just to jump ahead, it seems from Mr. Gordon's submissions that this case will come down to the 2 questions, really, but I am going to deal with a number of other points first. But those 2 questions are, first of all, is the withdrawal of CANH from a PDOC patient a sufficiently different category from all other patients who, first of all, are undergoing the withdrawal of CANH, or secondly, are undergoing and are not in a PDOC, or secondly, who are undergoing the withdrawal of some other life-sustaining treatment, such as, most obviously, ventilation. So we've got this very anomalous position, given the way that the legal history has worked, with Bland obviously concerning CANH, but it could have concerned ventilation. But it seems that a ventilated patient with CANH can have ventilation removed, resulting in their death, without any suggestion that anyone has to go to court, and all the self-same diagnostic difficulties, and I'll come to those. Diagnosis is a complex area, but there is extremely detailed guidance from the medical profession as to how it should be properly done. And I hope to illustrate that the cases that Mr. Gordon has shown you, which involved disputes in diagnosis could have easily avoided those problems where the diagnosis changed had the guidelines been adhered to. But returning to my theme, Mr. Gordon has to show, first of all, that withdrawal of CANH from a PDOC patient is sufficiently different from all other patients to justify a separate treatment. And in addition to ventilation, one can easily say dialysis, because in Aintree and James, one of the treatments was, although it was a ceiling of care case, not a withdrawal case, but the principles are the same. Let's say a PDOC patient needs the following. They might need ventilation, CANH, renal replacement therapy, and let's say they need antibiotics for a life-threatening infection. It seems that the other three, apart from CANH, can be withheld under the law that Mr. Gordon seeks to establish. He says both grounded in medical science and in the law, that he wouldn't have a problem with withdrawal of the other three types of life-sustaining treatment, but CANH somehow deserves a special category.
Can I ask about special categories? I mean, if one looked back at REF and West Berkshire, sterilisation seemed to be subject to a similar code. I think, were we told that was still the case? You came to court
it was
for that?
still in PD 9E until it was repealed on the 1st of December 2017.
So what other special categories have developed?
There is one other which...
sterilisation, has the practice actually changed now since the abolition of 9E, or does no one...
Not that I'm aware of.
No.
I think maybe people are waiting to see what happens in this case. Because
So what was
the
that
argument
one?
about PDs is that they don't have legal effect anyway. So
Yes.
once it's been repealed. There is one other category. I think bone marrow transplantation from memory is another one, which is, the way these categories have grown up appears to have been through the cases that happen to have come to court, where judges have said, well, it's really quite a good idea, because these are difficult cases, that they come to court. And they have somehow crystallized into a practice which then appears to be something that is a blanket practice without which there would be some form, as yet undefined, of illegality. But I'm going to come to that, the difficulty in working out what the illegality might be if one didn't stick to this practice. But I've addressed the first question that I think this case will turn on, whether CANH from a PDOC, withholding CANH from a PDOC patient is a sufficiently different category to justify separate treatment by the law. But then the second question must be asked and answered, and that is, after Bland, is there a sufficient body of experience and sufficient safeguards to justify lifting the blanket rule? And we say that there is plentiful guidance since Bland, and I'll go through it in a bit more detail later on, but just to give you a flavour of the changes, there have been very significant changes in the level of guidance for the medical profession. Admittedly, a further category of neurological consciousness has been identified in the Aspen Conference in 2002, the minimally conscious state, which is, if you start with coma, unconscious and no sleep-wake cycles, go to vegetative state with sleep-wake cycles, but still unconsciousness, minimally conscious state, which Mr. Justice Peter Jackson said rightly covers a wide category from just emerging into some awareness to almost full awareness, and above that you've got full awareness. So those are the various states, and there are various professional, very detailed sets of professional guidance which I'll show the court from the BMA, from the DMC, most particularly from the Royal College of Physicians in their detailed, I think, 100-page PDOC guidance, which I'm going to bore you very briefly with later on, but it just gives one a feel for just how much guidance there is.
Don't assume we'll be bored.
No, my lady, I was joking. It's of the essence to understand the seriousness with which the medical profession has tackled this extremely difficult challenge. This is not the only area of medical practice which poses diagnostic difficulties.
Was this put before the judge?
The PDOC guidance.
Yeah, I mean, did you make the submission that you're just about to develop to her?
Not in so much detail, my lord.
I mean, the case is changing shape then. The judge, the submission I'm just hearing is the sort of submission that one would expect if the judgment was to the effect that, of course, Bland was all very well in its day, but I'm now confident that there is a huge amount of very responsible guidance which is followed in practice, so that it's no longer necessary to insist on this rule of practice. That would be a very solid foundation for her judgment, but it doesn't appear to be there or to have been argued like
My lord, the case obviously has, there's been a leapfrog to this court. The case itself was argued on the basis of whether there was a legal obligation, even from Bland, to take cases to court, and in terms of the interpretation of the, I think, 5 or 6 cases there had been since. And Mr. Gordon is saying to the court that even if, that taking Bland in its own terms, there is no adequate body of guidance now. And as the respondent, I am obliged to respond to that submission made by Mr. Gordon. It wasn't argued in that.
Yeah, well, I think we did try to press Mr. Gordon on precisely what his case was, and it may
My lord,
be,
yes.
Maybe it has shifted even from his written case, because his written case is in terms of law. There's a rule of common law or
My lord, yes.
convention. So, I mean, I agree you have to deal with it. You can't be blamed. But
My lord, yes, I can't say nothing about that.
it is rather invidious for us as a
It is.
Supreme Court having to decide, really, a completely different issue, namely whether the guidance and the practice of the profession, which really is adequate.
My lord, yes, but the case, I think, the way that Mr. Gordon has put it, seems to have differed slightly to the way it was put below. And that's not by means of any criticism on my part, it's just a matter of fact. And I'm simply seeking to answer it in that way.
No, I understand that.
My lord, so my point here is that even if, and I say he's not right, even if Mr. Gordon is right, that there is a theoretically defensible means or reason to take out this very small subcategory of patients in whom the question of withdrawal of life-sustaining treatment arises. Because as I'll demonstrate from the figures, it's a very, very small proportion of the number of patients in this country who, in whom questions about life-sustaining treatment have arisen. Even if that is right, I say that there is plentiful professional guidance so as to satisfy, if their lordships in Bland were sitting again and looking now at the way things have moved on, they would be satisfied with the professional guidance. Medical diagnosis has moved on very greatly. Various types of imaging has come along since then. Legally, the law has been clarified. I mean, there are various legal safeguards, such as the specific mandatory considerations required to be taken into account in Section 4 of the Mental Capacity Act, which obviously was not in force at the time their lordships were deciding Bland, a very detailed code of practice describing just how one has to go about making a best interest decision, providing for consultation, mandatory consultation, Section 4.7, with those who care for P. And these are mandatory statutory obligations. This is not an optional procedure that those taking best interest decisions on behalf of incapacitated parties can ignore at their will. And if they're professionals, there would be serious professional consequences were they to simply flout the statute which provides for mandatory consideration of these matters. And the law has developed, and I'll come on to this, in terms of how we look at best interests after the seminal judgment of this House in Aintree and James. We know that there is now a strong element of substituted judgment in the best interest calculation, and the purpose of the best interest test following the Law Commission report is to put oneself in the shoes of P and ask the question, although it won't be determinative, of what would P want in this situation, having regard to his or her beliefs and values and wishes and feelings. And that has had a very important and clarifying effect on the law, because we have the contrast in W&M, which I will take the court to, where Mr. Justice Baker had evidence that P, in that case, wouldn't have even wanted to go into a care home, and yet, because it wasn't specific enough, it wasn't talking about withdrawal of CANH in an MCS, and Mr. Justice Baker placed almost no weight on that. And we can contrast that with, for instance, the Briggs case, in which there was evidence that Mr. Briggs wouldn't have wanted to live in that state, and yet the result went the other way. Mr. Justice Charles ruled that it wasn't in his best interest to continue receiving CANH. So because of the subjective focus of the test now that has been made clear after Aintree and James, the law has moved on, and the significance of that is this, in my submission, that lawyers advising parties in this case are much clearer as to what they need to do to ascertain best interests. So there is a plethora of legal guidance, professional guidance for the medical profession, and also medical technology has moved on such that the court in Bland, if they were to rule upon this question now, and Bland, of course, was a true landmark decision in deciding that CANH or ANH was a form of medical treatment, and it wasn't murder to withhold it. That was the extremely important landmark effect of the Lordship's judgment. And it's not surprising that the court wished to be cautious and to see what happened in that area at that point. But we are now 25 years on with the changes that I've described. The official solicitor in this case is seeking, in my submission, to go beyond the Bland case and create a substantive rule, not just a rule of practice. And I submit that such a rule, and I'll go on to describe why, would be inconsistent with the general permissive approach of the Mental Capacity Act, and also would be, as I've already said, inconsistent with the legal approach to withdrawal of any other type of life-sustaining treatment, which decisions are equally serious in that they also result in death. If you remove ventilation, it often results in death. Same for renal dialysis, where kidneys have failed, inotropes, where the heart isn't beating hard enough, and antibiotics, where a life-threatening infection is involved. So, in my submission, this is not a case capable of the wide significance that the official solicitor seeks to place on the case, threatening, he says, the sanctity of life of vulnerable patients, which engages the constitutional right of access to the court and the United Kingdom's treaty obligations. In my respectful submission, it concerns the essentially pragmatic question of whether a case law-generated rule of practice requiring court approval in the case of one form of life-sustaining treatment remains appropriate. And the continuation of such a rule of practice requires consideration on its strict merits, and in particular the question posed in Bland as to whether a body of experience and practice has been built up so as to obviate the need for an application in every case. This is not to say that applications will not be appropriate where there is a doubt as to best interests. And a doubt as to best interests can result from a doubt as to any of the constituents that go up to a best interest decision, the diagnosis, although I'll come to that, the prognosis in particular, and then a proper analysis of all the evidence of P's beliefs and values and wishes and feelings. So I'm not for 1 second saying that there aren't cases which ought to go to court, not least because the Section 5 defence, which I'm coming to under the Mental Capacity Act, would not apply in a case of serious doubt, because one couldn't be reasonably certain of what best interest was if there was a real issue. And that is how the MCA works, although I feel slightly awkward trying to describe to the Supreme Court how the MCA works. But the section...
Well, you have more experience of it than we do.
Well...
With the possible exception of my lady.
Well, But I will very briefly go through that. But the bottom line there is that the Mental Capacity Act is, as we know from Aintree, there to enable decisions to be taken on behalf of those who can't take those decisions. It doesn't go beyond that. And in cases of dispute, and this is paragraph 47 of Baroness Hale's judgment in Aintree, and I'll come to that, if there's a dispute over best interests, the case is taken to the Court of Protection, which then decides on behalf, it consents for P and provides the gap that there would otherwise be in lawfully providing for treatment. But the vast majority of decisions are not taken coming to court. In most best interest decisions, the vast majority of them do not need to be taken to court because, as we'll see, the Section 5 protection, which protects a party doing an act in relation to an incapacitated party, protects someone if they've taken reasonable care to ascertain there's a lack of capacity, and also they've taken reasonable care in relation to best interests. And that's the standard the Mental Capacity Act sets for all decisions, that reasonable care must be taken in relation to ascertaining capacity and best interests. And that's the standard in the civil law, so it's obviously logical that the Mental Capacity Act would adopt a similar standard. It would be odd if they had different standards. But that's the standard in respect of all withdrawal and withholding of life-sustaining treatment, apart from this subcategory of case. Now, of course, it's true that what constitutes reasonable care will depend on the seriousness of the decision. So you have to think much harder and make many more inquiries where it's a much more serious decision. But the general standard of care is that of reasonable care, and yet in this subcategory of case, regardless of whether there's any dispute, it has to be taken to court, according to rule of practice in Bland. I would also point out that there is no requirement to go to court for withdrawal of CANH in a patient with PDOC in two further situations. Mr. Gordon's referred to one of them, where there is a valid and applicable advance decision under section 22 to 24, and he says that's because P themselves have made that decision in advance. But there's a further exception to those cases that need to go to court, and that is where there's a lawful legal power of attorney extending to life-sustaining treatment under section 11.7c of the Act. I'm afraid you don't have that in your bundle of authority, section 11.7c. It cannot be said that the decision of the donee of an LPA is P's decision, and there must be a finite risk of a mistake, because that is the donee simply deciding. There are no procedural requirements that I'm aware of that require them to take a second opinion from an eminent specialist in PDOC, for instance.
And that could be a family member, could it?
It could be a family member.
So all the more you could have also the risk of
same problems
of mixed motives, maybe even unconscious.
Maybe, but what we see in the guidance is that I think families may have had quite a hard rap so far, in that they are often the best source of evidence in relation to wishes and feelings and beliefs and values. If one asks that question of oneself, who knows one best? And obviously, because it's an aspect of life, and life is very infinitely varied, that some types of evidence are more reliable than others. But that ought to be something that clinicians are able to be aware of. There are, I mean, the classic case is, that's come up in some of the cases, some relatives taking one view about what the person would have wanted, and another set of relatives having a different view, but there being a difference in the frequency of visiting between those two groups. And that does arise in practice. So these are not issues unknown to clinicians. But my real point here is that the requirement to go to court does not apply where there is a lawful power of attorney extending to life-sustaining treatment. And yet, if Mr. Gordon is right that this is some high constitutional right of access first to the court, even though there's no dispute, which I admit I have some difficulty with, although Mr. Gordon defines doubt as something that can only be defined after a third party, aka the official solicitor, has looked at it, which is, I don't think, the definition of doubt that I've seen in much case law in general in this area. Doubt either exists or it doesn't at the time of the decision. And it can be a matter of fact, or it can be a matter of medicine, it could be a legal question, but, the European Convention case law is clear, what a contestation is that it's got to be an actual dispute. But, as I say, that these problems arise in the LPA case, and yet, and Mr. Gordon has told this court that it doesn't really matter which other categories may also fall into this mandatory need to come to court. But that is the very problem, because if Mr. Gordon is right that these decisions are extremely serious, there is a finite risk of misdiagnosis, there is also a risk that the evidence on best interests is not accurate, well, all cases of withdrawal, and I'm afraid also withholding, because there's no difference in law, of any form of life-sustaining treatment ought to then come to court. Because on what rational basis can we choose this subcategory as somehow being worthy of a different level of protection? One might be able to find that need if there was some cogent evidence of a particularly high error rate in best interest decision-making in this field. I'm not talking about misdiagnosis, because the diagnosis between between coma, vegetative state, MCS, which is in itself a wide range, and full awareness, is one that takes a certain degree of care, and it's clear from the case law and the medical science that you can't simply rely on clinical observation. You've got to use structured tools such as the WIM and the SMART and the CRSR, which I'll briefly show the court. So you can't simply, a neurologist can't go in and simply diagnose the neurological state. You need to do these serial measurements over time and to see to what extent reproducible actions can be induced. How often do they press the button on being asked to press the button over a significant period of time? But none of that is anything to the point, because if one is sufficiently worried about the medical profession's misdiagnosis or errors in best interest decisions, and if a patient simply wants a good chance of getting back to their old state, it's not legally relevant whether they end up in an MCS, a VS, or even highly disabled and dependent on others, as was I think the best prognosis thought of by the treating clinician in this case, because the question is, can this treatment stand a reasonable chance of getting the patient to a position they would find valuable? And if they wouldn't value that state, then the precise sub-diagnosis within a neurological category is less relevant. That's why I say that it is absent cogent evidence of bad decision-making in this subfield as compared to all others, it can't be justified to single out this category. Now, there are a number of reasons in response to Mr. Gordon's submissions why I say there should not be a blanket requirement to bring cases to court involving withholding or withdrawal of CANH from patients in a PDOC. And there are, I think I've counted 10 reasons in all, I'm afraid. I'll try and describe them briefly. The first point is the domestic and convention jurisprudence provides no support for an allegation of a breach of Articles 2 or 6. And I rely in particular on Court of Appeal authority in Burke, which was obiter, Lord Phillips, which is Authority 11, MS 787, and also on the Lambert case, which held in the context of a case which was disputed, but which provided for the final decision to be taken by the doctor with the possibility, no more than that, of access to court, but no mandatory referral to court. And the court held in that case that the lack of mandatory referral even to mediation wasn't a breach of Article 2. Because the means in which disputes over these cases are to be determined, given the wide variation between Council of Europe countries on this point, is a matter within the margin of discretion of each country, and it's not something mandated by Article 2. So that's my first reason. There is no jurisprudence that supports an allegation of a breach of Article 2 or 6 absent a rule of practice, a mandatory rule of practice such as this. And stepping back, it would be quite odd, I submit, for there to be an Article 2 case that singled out this subcategory. Because, as Mr. Gordon said, I think in closing, one of his justifications for saying that these cases were just like the Conway assisted dying case, Nicklinson and so on, is that someone has a life and it needs protection. Well, that self-same justification must apply then to whether one can properly distinguish between removal of CANH from someone in the PDOC and removal of life-sustaining treatment from anyone else who lacks capacity. So it's unlikely that Article 2 would choose this subcategory as being the only one that warranted protection. Second point is, a blanket rule such as this, I say, potentially interferes with Article 8 rights. We know Article 8 rights are engaged by decisions concerning withdrawal of life-sustaining treatment in the light of the European Court decision of Pretty, which is Authority 53, I think paragraphs 63 and 65, but I will come to that case, it's in our written case. And having a blanket rule that PDOC patients' wishes cannot be followed timiously when clinicians, having followed relevant professional guidelines and family agree, is, I submit, unjustified and disproportionate, for it results in inevitable delay and possible expense in carrying out patients' wishes. And we know from Lambert, which I'm going to come to, Authority 7, paragraphs 142 to 3, memory stick 1032 to 3, that Article 8 is relevant to the scope of Article 2. The third reason is applying domestic law. Such a blanket rule means, and this is a similar argument, that there is an inevitable delay in providing treatment in accordance with P's best wishes.
Best interest.
Best interests, indeed. That means, and that's per my lady in Aintree at paragraph 22, which is MS 641, that there is an increased period that the Trust will have given treatment unlawfully to P due to the blanket rule. And in this case, and I will refer to the facts here, it was agreed on the 8th of September 2017 that Mr. Y would not wish for continued CANH if there was no good chance of recovering his previously active life, yet he was kept alive until the 22nd of December 2017.
Unlawfully, contrary to what?
Well, contrary to his best interests, we would say.
Well, contrary to Article 8, though.
Article 8 is one, I don't put it as high as there is a breach. I say it raises questions over Article 8.
I mean, it's...
The unlawful bit of it is that treatment is not lawful unless it's in best interests.
Indeed. One needs positive justification to be able to treat someone who lacks capacity.
But it's slightly circular, because if it's actually, as is argued against you, in the patient's best interests that there should be court supervision, then you have to put into the mix or into the balance the time which is inevitable in a court application.
Which is why I'm not saying that there is a breach of Article 8, but a question arises. Yeah. That's all I say.
I mean, the contrary argument would be, it would be unlawful to take legal advice, because it might take 48 hours.
My Lord, I don't wish to be unrealistic. These cases are not easy, and some require taking to court, some are very serious, and some do not. And this is simply a challenge to the blanket nature of having to take every single case to court. One size does not fit all, we say. But my Lord makes a good point. It's not necessarily unlawful until there's been a judgment on best interest. and that necessarily takes some time. That does beg the question whether the case needed to go to court at all. And all I'm saying is a blanket requirement of court means inevitable delay and expense if legal representation is required. Often the family would have to pay themselves. And as to the delay, these cases can take a long time. They can be quicker. In the case that you've been referred to, the witness statement, I think, in the supplementary bundle, took place, I think, within 8 weeks, but that was fortunate in that a joint expert unusually was agreed upon by the trust and the official solicitor. That is far from the norm, as one can see from the examination of the case law. And the official solicitor agreed with the trust's application. It was not contested. And I think the judge had a case come out and had a spare week that he offered the parties. Otherwise, I think, from memory, it was going to be the 26th of March, and it was brought forward by about a month. So even in a case where there was a joint expert, which is not what Mr. Gordon is asking this court for, he says the official solicitor, before we can know whether there's any doubt or not, the official solicitor must have his own exclusive expert, and only once that expert has reported do we know if there's any doubt. So the 2-month case is really not what we're talking about, even on a fast-track basis. And again, I'm not saying there aren't cases that require that level of scrutiny, but it cannot be said that every case is in that category. On that third point, the OS's third opinion received on the 8th of February 2018, the OS was notified on the 31st of October of this case. The opinion was received on the 8th of February, agreed that the prognosis was rather poor. And I say that it was highly likely that that opinion would have made no difference to the assessment of best interests on the facts of this case, assuming that the family's evidence that he wanted a chance of a return to his active lifestyle was accepted. The fourth point is the seriousness of the decision, which is the justification given in paragraphs 618 and 818 of the Code, on which Mr. Gordon places such reliance to the extent that that is apparently enough justification for doubting the conclusion obiter of Lady Justice Eleanor King in Briggs and Briggs. The fact that she doesn't cite, her ladyship doesn't cite paragraphs 618 and 818 apparently is a fatal legal error. But let's look at the consequences of 618 and 818.
Were you in that case, Mr. Solicitor?
I beg your pardon?
Were you in that case?
I was.
Well, can you respond to the challenge that the particular paragraphs of the Code upon which Mr. Gordon relies were not cited to the court?
My Lord, I was the OS in that case, and we didn't make submissions on that point. We were not expecting that to be a live issue in the case. It was just an issue her ladyship chose to comment on.
Mr. Gordon may be right about that.
But that's the same in W&M. There wasn't detailed argument over whether every case had to come to court or not either. We didn't cite Burke to Mr. Justice Baker either. I mean, these older cases must be looked at with some circumspection. If it wasn't one of the central issues, it is obviously obiter. And if there weren't submissions on it, in Re-M, Peter Jackson case, the official solicitor wasn't a party, but was asked for detailed submissions which were determined on the papers. There were no oral submissions. But the official solicitor is entirely right to submit that the comment of Lady Justice Eleanor King in Briggs and Briggs was obiter. It simply wasn't argued about in a proper fashion. But that's not to criticise her ladyship, because I say she's entirely right. That's an entirely accurate statement of the law. It simply isn't binding, and its persuasive value has to be reduced by the fact that it wasn't the subject of detailed argument. But my point 4 is that the seriousness of the decision could not, which is what the Code of Practice says about why you have to bring these cases to court, can't justify this sort of a rule, because it would then logically apply to all life-sustaining treatment. Because where the seriousness of the case is in the fact that the patient will then die. And that cannot logically be used to justify a rule of this shape. And Mr. Justice Peter Jackson also refers to this point, Authority 14 in Re-M, 37 subsection 2 MS 951, but I'll come back to that. The fifth point is, which is one I've made briefly already, and I won't spend much time on, the only possible potential justification for this sort of rule would be the exceptional risk of error in relation to best interest decision-making, absent court involvement, but there's more to it, in cases which were consensual. So we're not talking about the St. George's and P, where the family said, he's responding to us, he's not in a vegetative state, he's minimally conscious. And the trust first didn't allow the family to video, and then having seen the videos, the court ordered videoing, simply didn't interpret it in that way, so as to justify an MCS. But St. George's and P, where the diagnosis of the doctors, which was vegetative state, was found at court to be minimally conscious, was a highly contested case. So we're not talking about the risk of errors with this rule in cases that are highly contested. And so that's why some care is required. And there's another case, which isn't in the bundle, called Riel, Mr. Justice Moylan, in which, again, the family were seeing more responsiveness than the hospital, and video evidence, again, gave rise to a change in the neurological diagnosis, if not the clinical trajectory, which is another thing altogether, because you can have a slightly better neurological diagnosis without necessarily changing the trajectory that much. And then the third case, the Abatawi and RY case, which the court's already been referred to, was also a highly contested case where the doctors thought that the patient was in one neurological state and the family was convinced that he was in a higher state. And again, video evidence proved to Mr. C, who in that case made the diagnosis, that it was in that case. But that was, again, a highly contested case. And obviously, the risk of error in a highly contested case as to diagnosis, prognosis, best interest will be higher than in one where relatives with a heavy heart accept the not very favourable prognosis put in relation to a particular patient and know in their hearts that the person wouldn't have wanted it. I don't think, in general, many relatives and friends would come to this judgment lightly. And the professional guidance makes it very clear that proper inquiries need to be made. It's the basis for saying someone wouldn't have wanted this.
What about the person who doesn't have any family?
An IMCA under section 2037 must be appointed, independent mental capacity advocate. Their job is to look thoroughly into all aspects of best interests.
Can they get a report?
I believe so. I believe so, yes. But they have strict duties towards P. I mean, that's what they're there for, to inquire into best interests. So, but it may be that there is a dearth of information available on best interests in a particular case. And it may then be that a consultant doesn't feel happy to withdraw CANH in the absence of that evidence, because if they're properly advised, they'll realise that the Section 5 defence, and we're coming to Section 5, may not protect them from liability if they haven't done enough. And in some cases, enough may require referral to court. The sixth point, and sorry, just to finish the fifth point. So what I say is the only possible justification would be proving the exceptional risk of error in consensual best interests cases absent court involvement, and there is no such empirical evidence of that. The sixth point is that the critical question in these cases is not necessarily the likely end diagnosis for P. PVS, MCS, awareness with significant disability or awareness without significant disability, but depending on what P would have wanted, whether the best realistic prognosis is one that P would value.
Sorry, this is the question. I've not quite got the...
The best interest question
Yes.
in these cases is not which subcategory of MCS is the patient in.
Yeah.
That is a really interesting medical question, and the neurological rehabilitation doctors are very interested in that. But the question of law is continued CANH such as to give a reasonable prospect of a life that P would have valued themselves? And some Ps, like in the Briggs case and like in this case, have high expectations of life. They would only want to be active. In the W&M case, the Baker case, the P said, don't even let me go into a care home. So that was the level of activity and quality of life she wanted, and yet she was in an MCS with a life expectancy of 10 years with no obvious prospect of improvement. But the key question is not in every case what's the diagnosis. It is what is the prognosis, and does that accord with the best realistic prognosis, because one never knows where a patient's going to end up. There's a range of likely outcomes. But if the best realistic outcome is still significantly below what that person would have wanted, then there can be the basis of a decision that CANH should be withdrawn.
It's a curious, seems to me a slightly curious concept, and I hope I'm not being too light about it, but there can't be many families who come along and say, oh, he wasn't really active, he didn't enjoy, what he really enjoyed was just sitting by the fire. And on that, on the sort of reasoning you've adopted, that would mean that you didn't consider withdrawal because it doesn't sound very realistic. I would have thought that how big a factor is this really? How much influence does it actually play?
We could think of the Aintree case.
Yes.
The Aintree case is a very good example.
Very good example.
Where the family who visited Mr. James in hospital every day for long periods,
hours,
said he enjoys his life.
Yes, well, that's a...
But it can work both ways.
If you describe his life to many other people,
yes,
it would be intolerable.
Yeah.
Because you could have the other thing. Somebody might say, well, if I'm in PVS, I don't care what happens. But if I'm in a minimally conscious state, the last thing I want to do is to be kept alive in a minimally conscious state.
Yes.
That's a view that a person might have. In other words, they might be more bothered about the minimally conscious state than
They
about...
might. That were for good reason.
The one where there is absolutely no consciousness.
Yes.
So there's a wide range of views that people might have.
There is, but my point is simply this, that the best interest question turns on whether the best realistic prognosis is likely to be a state that this P would value, rather than, because most Ps don't express their preferences in terms of minimally conscious state or PVS or MCS minus. If you really want to split hairs, the PDOC guidance suggests a division of MCS into MCS plus and MCS minus. Those aren't the terms in which people express their opinions. And that's why focusing on misdiagnosis, inverted commas, in contested cases is not a good way of inferring the degree of risk from not requiring all consensual CANH cases in PDOC cases to come to court, because they're not the same thing.
Your emphasis on the subjective wishes of P, when was that established in our law as the focus? Can you remind me? You did mention it earlier.
It's Aintree and James, Baroness Hale's judgment. I will
It's Aintree, yeah.
Going through that.
But it's also in the best interest criterion
It is.
in the Mental Capacity Act.
In various places, the Law Commission report, I think it's fair to say that it was made extremely clear in Aintree that that was the law. That wasn't necessarily the way all the cases went before that.
Okay.
So the references are Aintree, the 8th authority, and Briggs, the 10th authority. And errors in the best interest decision, as opposed to errors in the PDOC diagnosis, and that's what I want to distinguish, we know that there are errors in the PDOC diagnosis of around 40%. We find that in the W&M case and various other references that you've been given. And this is in non-specialist units. And there are some pieces of research that I'll point out to the court. But that's the rate of error of diagnosis in non-specialist units. So that's not following the PDOC guidance, which requires referral to a specialist neurorehabilitation unit for serial observation, which is, and that's the guidance we've got that binds doctors.
Sorry, I missed the reference. Where is the error in diagnosis?
The error of diagnosis
Page.
of about 40%.
No, sorry, what page are you on?
I'm
No,
not
it's just
on a page
okay.
yet. These are supposedly just my introductory remarks.
Right,
I'm
sorry,
afraid.
right.
Well, we were, of course, told that also by Mr. Gordon.
Well,
And
I
refer
can
to
do no better than Mr. Gordon in that. Maybe I will be getting to the main part of my submission soon.
Well, you haven't got much longer
I
this
know.
afternoon.
No, I know, my lady. So my simple point here is that an error in the best interest decision is not the same after following the PDOC guidance, having the specialist referral to the neuro-rehab centre, of which this is one. This is a 1A centre. I think one of the only, it's a certain level of centre. There are a number in the country. But errors in the PDOC, in the best interest decision, are rare. And we see that from the supplemental authorities, Volume 1, Number 4, Supplementary MS 49. You've been referred to that already. I think Lord Mance pointed out the ambiguity in tab 4 in a number of bundles, but that's the supplemental authorities. So errors in best interest decisions in this field are in fact rare. And I rely on that, and also the paucity of examples of mistakes that the official solicitor has drawn attention to in otherwise consensual best interest decisions in this field, as opposed to cases that have gone to court where both sides differ fundamentally as to diagnosis and prognosis, and the judge goes one way or the other, or in a third direction. Another way of putting it is, what evidence has been provided that a significant level of error in best interest decisions relating to CANH in PDOC patients would otherwise be made? The next point is that there is no clinical justification, just from a medical point of view, for distinguishing this group of patients from other patients in CANH, in whom CANH is regularly withdrawn in clinical practice without recourse to the courts. And can I commend to you the materials of the BMA and also the ICS, the interveners documents? They are an invaluable insight into the way in which this works in practice. It turns out that in intensive care, and I'll come to that, CANH is regularly withdrawn from patients after a consensual procedure with patients' families, along with other life-sustaining treatments. And there's been no suggestion that those decisions, which are very numerous, as we'll see, I've got some numbers for the court, need to be taken to court. And there's also this third category that the BMA refer to, who are those who are fully aware, so they're higher than minimally conscious state, but who have other serious conditions, such as a severe stroke, and who, but for the withdrawal of CANH, could live for a significant period of time. So they might be on a downward trajectory, but they're going to live for some time. They are not near the point of death. And yet CANH in practice is removed with agreement from the family after a best interest procedure in this group of patients. And they are a higher level of awareness than a minimally conscious state. And yet the OS is not saying that those decisions should also be brought to court. And that's the BMA written case, paragraphs 14 to 15, supplementary page 74. CANH is, I've already said, routinely withdrawn from patients in ITU, and those cases don't have to come to court. Last two general points. There's a deterrent effect, as pointed out by Mr. Justice Peter Jackson, paragraph 37.3 in REM, which is Authority 14, MS 951. It's a deterrent effect of costly and time-consuming proceedings, leading to the risk that clinicians and families will be deflected from making true best interest decisions, and in some cases lead to inappropriate treatment continuing by default. It's not every family that is willing to go to court and be subject to the very high level of scrutiny, such that, for instance, in the Riem case, the fact that photographers were trying to take photos of the family through a long lens led to a reporting restriction order plus an exclusion zone, which we see from the media judgment in the Riem case, W&M case, and various other cases have led to great distress. The family in M were understandably very stressed at the proceedings. In the Briggs and Briggs case, you can see Mr. Justice Charles' description of the stress the family went through in having to go to court. These were cases of a dispute as to best interests. I'm not saying that those cases didn't have to go to court, but what we're saying here is that even where it's consensual, it has to go to court. Finally, we note in this case, and I think the court's been sent this letter from Mrs. Y in this case, that 9th of February 18 letter from her solicitor. This is an exceptionally difficult time for her. She is struggling to cope with her grief and loss. The remaining issues are of immense importance more generally, but not matters that will be relevant to our client. She's advised us she does not propose to play any active role within these proceedings. We hope that the court will accept she shouldn't be required to take any steps. We're aware our client is fragile and has mixed feelings about the matter. So there is the stress and anguish placed on family members, and this was a consensual case, cannot be underestimated. And in some cases, in my submission, it will mean that these issues won't get to court and patients will be treated inappropriately as a result, because there will be no adjudication on their best interests. Finally, and I rely in particular on Authority 54, report of Dr. Fickfack, the comparative literature reveals that very few countries require court approval for lawful withdrawal of CANH in PDOC, and most consider it sufficient to permit doctors and families to decide, with the possibility of referral to court in the event of a dispute. And there are 3 or 4 references to comparative materials, the Halliday study as well in 2015. My lady, I wonder if this is a convenient moment.
It's a very convenient moment indeed. It would be convenient even if you had more than 2 minutes left. Well, we'll look forward to hearing from you further at 10:30 tomorrow.